Okay, hello, good evening. This is James in Violon, and welcome to Wiser Pinoy TV. And I would like to welcome all the aspiring registered criminologists. So I know that you are waiting for me to go live so that we will be able to discuss some salient points under the Criminal Law Book 1. So this is just a part 1 because for all we know, we cannot really discuss everything under this principle. Okay, so without so much further ado, let us discuss the most important concepts under the Criminal Law Book 1. So, under the Article 1, so for all we know that in Article 1 of the Revised Penal Code, it states the title of the law, while the second or the section Article 2 it simply enumerates there the exemptions of the extraterritorial um, preference, or what we call the extraterritorial principle. So we have to remember that under the revised penal code, meron tayong tinatawag na characteristics ng criminal law. So there are three. One is the generality, the second one is the territoriality, and the third one is the prospectivity. Now, under the generality, we have to remember that by general rule, all people, all Filipinos, including aliens who are sojourning or visiting the Philippines, they are subject for our penal code or our criminal law. However, we have exemptions to that. Example is the ambassador. So, for example, an ambassador from other country who is assigned here in the Philippines, we cannot file them criminal suits or criminal cases. So, because what's the difference between the ambassadors and the consul? We have to take note that ambassadors represent the political interests of the sending state to the receiving state. So, ang Philippines is the receiving state. So, kung saan ang galing yung ambassador, that is the so-called sending state. This is why they are immune from any criminal suit within the receiving states. So, that's very clear under the revised penal code. Now, let's proceed to section 2 of article 2 of 1987. So let's just touch the doctrine of incorporation. So parang customary yan for states to respect each other. So under the political law, so par in parem non habet imperium. So all states are sovereign, equals, and cannot assert jurisdiction over each other. So if you're suing a representative of a sending state like an ambassador, so it's like you're suing the state. So they being equal, they cannot assert jurisdiction over the other. So that's very clear. So all states are equal by they have to respect each sovereignty. So those people who are representing the political interests of that country, who are called ambassadors, they are immune from any criminal suit within the receiving states. Now, let's proceed to the consular officials or the consuls who are representing the commercial or economic interests. So, nakita niyo yung difference between the political interest under ambassadors. So, take note, the ambassadors are representing the political interest of the sending state, while the consular officials are representing the commercial or economic interests. What's the main difference also? While the ambassadors, they are immune from political suit, or they are immune from criminal suit. I mean, these consular officials, they are not immune from what we call criminal suit. However, they cannot be arrested or they cannot be detained. So, even if the consular officials, they are not immune from criminal suit, but take note ha, hindi sila pwedeng hulihin at hindi din sila pwedeng i-detain. That's the general. Kailan ba natin, pwede bang mahulihin sila, sir, or pwede ba silang i-detain? Yes, they can be detained or pwede silang hulihin. We have to remember, if ang gravity ng offense na na-commit ng consul is napaka-intense na. Like say for example, a consul committing a murder or a rape, that is already very grave in our penal code or in our criminal law. So in that condition or circumstance, the the police officers can actually detain and arrest now the consular officials or the consul. That is the rule. Pwede lang silang dakpin if napaka-intense or grave felonies ang nakomit nila. Now, example, a consular official was arrested for reckless imprudence resulting to damage for property. So if you are the counsel or if you are a police officer, would you arrest the consul? So of course, um, i-touch muna natin ang legal aspect ng ano natin ng situation. So bigyan mo natin ng bail at saka writ of habeas corpus. So those are the basic remedies. The consular officials can be charged but can neither be prosecuted nor be subject to any arrest and detention, except again yung na-mention ko kanina, when they commit grave crimes. So when we speak of generality principles, so we think of its exemptions and who are covered under such principle. So that is our thinking when we talk about generality. Now let's proceed to the territoriality as the second characteristics of our criminal law. So when we talk about Article 2, this talks about the venue and begs the question of whether you can prosecute the accused or the offender. So the rationale for this is criminal cases are territorial in nature. So we have to remember na pag may isang murderer na dadakpin ng mga pulis, at itong murder na to is nag-cross na siya sa border ng Philippines. So let's say nakapunta na siya ng Malaysia. Question, pwede pa bang hulihin ng mga pulis ang murderer na lumampas na sa territory ng Philippines at nandoon na sa Malaysia kahit kaya pang abutin ng kamay? The answer for that is no. Because babalik ulit tayo kanina sa principle na tinuro ko na our criminal law is territorial in nature. It only applies within the territory of the Philippines. Now, hindi rin siya kasali sa exemptions because yung exemptions lang dito is yung mga ambassadors representing the political interest of a sending state. A murderer, yung example natin, is just an ordinary person who just passes by to the other boundary of Malaysia. So the police enforcers or the Philippine policemen can no longer have the jurisdiction to arrest the person. So hindi na. Kasi pag i-arrest nila yan, now, the person or Malaysia, of course, matatouch yung ego ng Malaysia because alam ng international law niyan na hindi pwedeng dakpin, especially, hindi na muna natin itatouch yung extradition treaty. So, it's very clear here na walang jurisdiction kasi territorial in nature yung criminal law natin. So let us discuss the exemptions, no? But before that, what is the general rule? The law is very clear that criminal law shall be applied within the territory of the Philippines. So what is the exemptions to this? In those cases where it would be given extraterritorial applications, yung sinabi ko kanina na extraterritorial applications are those mentioned under Article 2 of the revised penal code. So you have to take note this, guys, especially those who will be taking the criminology licensure examination this December. I hope you have a codal there or you have exerted an effort to at least secure yourselves a copy of a codal of the revised penal code because that would serve as your guide of the law. So if you happen to have a codal, kindly mark Article 2 there as a very important provision. So the exam in the criminology would not be very interesting without that principle under Article 2. So those 5 exemptions, you have to take note of those. Okay. So let's relate now crimes committed by public officers under Title 7 of Book 2 of the Revised Penal Code, which can be specifically found under Articles 203 to 245. Now, in paragraph 1 and 2, these are self-explanatory. So paragraphs 3 and 2 are interconnected. That's under Article 2 of the Revised Penal Code. Don't get confused. However, mark paragraph 4 of Article 2 as a very important provision because that is the most important among them. Okay? So what are the instances of extraterritorial applications? So take note, guys, that the Revised Penal Code can be given application even if they are outside Philippine territory. So the offenders here are not only Filipinos but also aliens. So don't confine your idea na Filipinos lang makakakommit niyan. Even foreigners are also subject to this paragraph. So paragraph 4, while being public officials, they commit offenses which are work-related. Let's say, for example, an ambassador, a Filipino ambassador assigned in the United States of America committed a falsification of public documents or bribery. Let's say bribery. Kinasal niya yung couple doon, Filipino couples in America na wala man lang mga papeles or documents na necessary for the marriage, for the security of marriage contract. So let's say kinasal niya yun, binayaran siya, there was a corruption of public official, and the ambassador took the bribe or the what they call this, the money. So that constitutes already a direct bribery. Now we can prosecute the ambassador even if he is in America and not here in the Philippines because take note, function related yung kasalanan niya because he acted as an ambassador celebrating a valid marriage even if there is not valid marriage, celebrating a marriage even if there was no physical compliance or substantial compliance of the, what do you call this, requirements for marriage. Okay, so question, nung nang-rape si Consul na naasan sa Taiwan, let's go to Taiwan, can he be prosecuted here in the Philippines? Can he be? Of course, the answer is no because alam naman natin na hindi naman function-related ni Consul ang mang-rape. Okay? Can you understand that? So, we can only prosecute a consul or ambassador if they commit a crime which is function related. If not function related, the Philippine law, the Philippine criminal law, to be specific, cannot be applied for that person. So paano yun? Paano natin i-resolve yun? Well, the Taiwan penal law or the law of Taiwan will apply to the consul, not the Philippine law. Okay, that's very clear. Now, here in the Philippines, pwede siyang tamaan ng Republic Act 6713 o yung Code of Conduct, no, professional or ethics natin as a public employee or public official. So, the conduct unbecoming of a public officer. So, let's proceed to another example. Next thing that we need to know is what if a crime committed by a public official is in connivance of a private individual. So here, mayroon ng connivance ng private individual. So, titingnan natin kung sino yung kasama niya sa crime. Paano yung mga private individuals? So halimbawa, one of the functions of the consular official is to solemnize marriage abroad. That's very basic. Dobi, wala yung mga marriage license ng mga Pinoy na nagpakasal abroad. So they bribe the consul. So this is the same with my example. Ambassador lang yun kanina. To make it appear that they have the necessary requirements required for marriage. So kinasal sila ni consul sa isang hotel. Take note, the marriage was celebrated in a hotel. So the consul made it appear that all the requirements are there. Now question, can you charge the private individual who bribed the consul and the consul who celebrated the marriage? Did the private individual commit a crime? So the answer is yes, they committed the crime of corruption of a public official. However, they cannot be prosecuted because corruption of a public official is not among those instances enumerated under paragraph 4 of Article 2 of the revised penal code. So, when when a public official committed a crime together with a private individuals, you check what crime was committed by them. For example, if they committed a falsification of public documents abroad, they cannot be prosecuted here in the Philippines because that is not one of those crimes enumerated under Article 2 of the revised penal code. Kaya dapat nating i-master yung 5 instances under this provision because para prepare tayo if ever lalabas ito sa board exam as a situation, alam natin kung paano siya i-analyze. So the question asked in Article 2 is, can you prosecute the accused in the Philippines? So that is always the question that you should ask whenever you encounter this kind of situations. So if the crime is committed within the Philippine Embassy, another story. Okay, take note yung mga examples natin kanina is conducted hotel. So, but if it is committed within the premises of the embassy, that's another story. Because under the principle of exterritoriality, embassies are considered as the extension of the territory of the Philippines. So, halimbawa, if nasa Amerika ka at pumasok ka sa embassy, under the legal perspective to that is it is as if tumungtong ka sa lupa ng Philippines. So if you have committed any form of crime, offense, or felony within the premises of the Philippine Embassy, automatically the revised penal code or the criminal law of the Philippines will take over or will take charge. Thus, even if you are an alien or a Filipino, so long as you committed a particular wrong within the Philippine embassy, you will be subject for the Philippine criminal law. So that is very basic, guys. Okay. So in criminal law, there is what we call partner's crime. So I do not know if you are familiar with partner's crime. So meaning one cannot exist without the other one. Example is a felony of corruption of public official cannot exist if there is no direct bribery. Take note of that. Halimbawa, if ako ang mayor and mayroong dalawa na couple na inas nila ako that gusto nila magpakasal. So, here comes, wala silang mga papeles because yung lalaki pala is kasado na. Meron na pala itong asawa. So, under the Philippine law, they cannot be really celebrated another marriage because that would result to bigamy. Okay. So, assuming, alam ko na wala silang papeles, alam ko na illegal, pero binayaran nila ako ng 100,000 just to celebrate their marriage. I accepted the money. So, ang kaso ko is bribery. That's very clear. But hindi ako magkakaroon ng kaso ng bribery if walang corruption of public official. So yung dalawang nag-bribe sa akin, ang kaso nila is corruption of a public official. While sa akin, it's direct bribery. So if hindi ko i-accept or hindi ko i-accept yung yung binayad nila, wala akong kaso. Okay? So that's very clear. They are called partner crimes because ang direct bribery will not exist without the corruption of a public official. Now, if you have questions, now since live naman tayo, you could actually, what do you call this? You could actually type the question so that we could answer that kung mabasa natin later part. Okay. Let's proceed now to Article 333 and 334. So we will touch adultery and concubinage respectively. So question, what if, di ba alam naman natin sa difference ng adultery, concubinage, and bigamy. Adultery if ang may asawang babae, a married nagkaroon ng sexual intercourse or sexual relationship sa isang lalaki na alam din niya na may asawa yung babae. So, the felony committed there is adultery. While when we say concubinage, ito yung kaso natin sa lalaki na may asawa din na tao na binahay yung kabit niya or yung babae na alam naman din yun ng babae na may asawa yung lalaki but they chose to cohabitate or do scandalous activities, no? Yun yung nasa elements ng concubinage. Okay. Ang bigamy on the other hand is, ito yung felony na nakukumit natin na may asawa na ang isang tao, mayroon siyang existing or subsisting marriage, ay nagpakasal sila ulit without first annulling or canceling, let's say, hindi pa namatay yung partner niya or hindi man lang naanal ang kasal niya, ay nagpakasal siya ulit. So, naging dalawa yung kasal niya sa existing sa civil registrar. So, in that way, the crime committed there is bigamy. So, you cannot say actually na nagsama lang yung babae at lalaki na may asawa, bigamy na yun. Because bigamy is a felony committed when there is a subsisting marriage, then nagpakasal ulit. Okay, so that is what we call the bigamy. Now, what if a bigamy happened abroad? So, can you prosecute them? So, clearly, the answer is no. They cannot be prosecuted because here in the Philippines, they cannot be prosecuted here in the Philippines. Pero pag umuwi sila dito sa Pilipinas at magkasama pa rin sila, they still live in one house as husband and a wife, then they can be charged now. What crime? The crime committed is concubinage or adultery as the case may be. Itong adultery kasi, this is a gender crime. When we say gender crime, this is only exclusive to a woman and a man. Now, question, what if doon nagpakasal sa New York, sa United States of America? So, valid ang same-sex marriage doon. Pareho sila na babae. Now, yung isang babae is may asawang lalaki dito sa Philippines. Then, umuwi sila dito sa Pilipinas, magkasama pa rin sila kasi they believe the validity of their marriage in New York. Magkasama sila in one house. Can you charge them adultery? No. They cannot be charged adultery because under Article 333, this is very clear when it provides that the crime of adultery cannot be committed by both women. So, kaya sinasabi natin gender crime ito. Take note of that. Dalawang babae, may asawa yung isa, they cohabited each other. So, yung lalaki, hindi siya pwedeng mag-file ng adultery sa asawa niya because klaro yung batas natin dito sa Philippines. When it comes to adultery, it is only committed by man and a woman, not both women. Another question, can you charge them with an impossible crime? So we know for a fact that impossible crime is technically is not a crime, but it is only added in the revised penal code in order to prevent the propensity of an individual to commit a crime. But it's not really a crime. Pero may punishment siya sa revised penal code, making it appear as a crime. But again, technically, it's not. So can you charge them with an impossible crime? Okay, if you could recall your impossible crime, no. Because impossible crime will only exist if the crimes committed are against property and person only. Okay, so adultery is a crime against chastity. So hindi siya a crime committed against property or person, which is scope ng impossible crime. You always remember that impossible crime can only be invoked under what do you call this? Criminal acts against property and a person. So if you could remember the Latin maxim nolum crimen nulla poena sine lege, it is a legal principle which requires that one cannot be punished for doing something that is not prohibited and punished by law. So this principle is accepted and codified in the modern democratic states as a basic requirement of the rule of law. Take note, isa ito sa mga issue na ni-raise ng kampo ni Maria Ressa sa cyber libel case niya because take note that cyber libel case during the time na commit niya yung crime is few months pa before nag-take effect. So ngayon ang question nila is, hindi ba ito saklaw ng ex post facto law? Because um, ang cybercrime law was only made few months after na-commit, allegedly na-commit ni Maria Ressa yung cybercrime. So, alam naman natin that's very elementary in the study of law na ang isang batas, isang penal law na batas ng kriminal ay hindi siya pwedeng mag-take effect backward. It should be prospective. Yan yung third na characteristic ng criminal law natin. It should be prospective. So it should not look backward, but it should move forward. Okay. Now, let's try to touch VAUSI or violence against women, anti-violence against women and children under Republic Act 9262. So under Article 2, yung enumeration natin ng paragraph 1 to 5, may additional dyan. Okay? In the case of VAUSI or anti-violence against women and their children, when the crime is committed abroad, but if one element is existent here in the Philippines, the accused can be charged and prosecuted here in the Philippines. So that's new to us kasi nga bago itong VAUSI din. So yung case na to is VAUSI case in 2018. This is an actual case decided by the Supreme Court. Ang nangyari dito was the psychological violence was committed abroad, pero yung effect niya nandito sa Philippines, nandoon sa family ng babae. So the elements of psychological violence were felt here in the Philippines. So the Supreme Court said that although the offender was abroad, he can still be prosecuted here in the Philippines because the elements of the psychological violence happened here in the Philippines. So that's very new and clear. So wala namang problema yung paragraph 5 kasi crimes against the nation man ito. So anywhere they can be prosecuted like piracy, rebellion, treason, etc. Now, let's discuss the doctrine of pro reo. So ano ba yung doctrine ng pro reo? So in criminal law, in case of doubt in the interpretation of law, it should be strictly construed against the state and liberally construed in favor of the accused. Ano bang ibig sabihin nito? Let's say, merong dalawang interpretation. Pinaka-example nito is, yung evidence ng prosecutor at ng defense equal. Yung tinatawag natin Equipoise doctrine or Equipoise evidence. Equal, so 50-50. So, since nalilito ka kung ano ba talaga ang ano nito, paano ba to i-resolve? Pwede bang hindi i-resolve? Of course, no, because the judicial or the judge of a court is required to render judgment. So, ang interpretation niyan is kung ano yung in favor para sa accused, yun yung papanigan. So, in an equipoise, an equal yung evidence ng both prosecutor at ng defense. So, ang gagawin niya ng judge is i-acquit niya yung defendant, then, yun, ma-acquit yung case ng defendant because equal nga yung equal yung way ng evidence. Another example is kung may dalawang batas, may dalawang batas pertaining in one act or crime committed. So ano yung batas na favorable doon sa accused? Ito yung gagamitin na batas, hindi yung napaka mabigat. So yun yung doctrine of equipoise in a layman's term. Now under Article 3, now Article 3 is asking the question how a felony is committed and how felony may arise. So ito yung concern. Paano ba nagiging liable ang accused? What makes a anong tawag nito? Perpetrator liable of an offense that is under Article 3. So it gives you two ways of committing a felony. Take note of that, ha? There are two ways of committing a felony. One is through intentional felony or what we call dolo. And the second one is through unintentional felony or culpa. Ito yung may intention at ito yung isang hindi intention, but both are felony or subject for criminal liability. Bakit sila pinag-iba? Because of the penalty imposed and the propensity of the person to commit the crime. So, Under Article 3, it tells you how a felony arises. When a felony arises, we have intentional felony. The following are the requisites of intentional felony. One, freedom of action. So there is freedom. Second, intelligence. And the third one is criminal intent. You want to take note, guys, that in the absence of these elements, there is no dolo. All of those elements must be present. You have to take note of that. Now, without the intelligence, there is no criminal liability. Example, a 15-year-old, a juvenile offender, no, committed a rape or a murder. So under Article Republic Act number 9344, they are exempted because of lack of intelligence or discernment. What if wala yung freedom? If you are acting under the compulsion of an irresistible force, you do not have freedom of action. So you are prevented by some lawful or insuperable force. Wala kang criminal liability. Let's say, for example, patayin mo siya o ipapatayin kita. So you are under compulsion of an irresistible force. So wala kang criminal liability because you don't have the freedom. Yung element ng isang one of the most important elements of idolo. Now, take note that criminal intent is the most important part of to determine the accused. So the prosecution here is obliged to prove the guilt of the accused beyond reasonable doubt. That is the highest form of evidence or anong tawag nito? Ito yung mataas na klase ng ebidensya na dapat i-achieve ng prosecutor before niya mapaprosecute or mapapakulong yung isang offender. Okay. Like example, a murder as a felony, kailangan may intent to kill. So question, if Mario is walking, no? Naglalakad si Mario, ay tinutukan niya ng baril si Juan. Pero binawi lang din niya because he was no intention to kill Juan. Can Mario charge Juan? Can Juan charge Mario with attempted homicide? Tinutukan siya, pero binawi lang din niya. Okay, let's review our concept on attempted felony. No, hindi pwedeng kasuhan ni Juan si Mario because there was no intent to begin with. However, if ang baril is hindi lisensyado, alam naman natin na may punishment yan. That's malum prohibitum, diba? So, Mario now can be charged with illegal possession of firearms, which is, again, a malum prohibitum. Take note, guys, that in a special law or special penal law, good faith is not a defense in a malum prohibitum. So those punished under the special penal laws where intent need not be proven. So hindi kailangan ng intent. Let's say, for example, child abuse, no? Child abuse. Hindi mo alam na bata pala yung inabuse mo. So, kesa alam mo or hindi, the court will not use that or that's immaterial. Wala yung impact sa kaso kasi klaro that in a malum prohibitum, a law prohibiting an act, hindi niya kailangan ng intention. Okay? So those punished under the special penal laws where intent need not be proven, intent is not necessary anymore. So what we mean by that is intent to cause damage, the malice is not necessary because there is still intent in the crimes which are mala prohibita. So the intent there is not to commit a crime, but intent to perpetrate the act. So there is still intent. It's not the malice that we are talking about. So we have to distinguish between malum in se and malum prohibitum. Okay? In the information under mala in se, the word intent must be emphasized in the information. Example, that on or before 2nd day of December 2019 and for some time prior and subsequent thereto in Valencia City, Philippines, the said accused conspiring and confederating together and helping each other did then and there willfully, unlawfully, and feloniously defraud Maria Clara in the following manner. To which, so enumerate mo yung act na ginawa niya under sa affidavit. So this is very important to distinguish mala in se and mala prohibitum, because let's proceed now to the second felony, which is unintentional or culpa. So the requisites here are freedom of an action or freedom of action, intelligence and the negligence, imprudence, lack of foresight, and lack of skill. So in culpable felony, good faith is not a valid defense. Your defense is the exercise of due diligence. So kung culpa pala yung case mo, no, lack of foresight, so ang defense mo pala dito para hindi ka maging criminally liable is the exercise of due diligence. Or depende kung ano yung required na klase ng diligence. Kasi meron din tayong tinatawag na extraordinary diligence. Like for example, drivers. So the kind of diligence that drivers are necessary or required is the extrajudicial diligence. Hindi lang yung ordinary diligence or diligence of a good father of a family. Hindi lang yun yung required na, but an extraordinary diligence. Okay. So, let's differentiate motive and intent. Okay, motive is the moving power which impels the person to commit a crime, while intent is the purpose or using a particular means to bring the desired act. Take note, guys, that motive is not an element of crime, while intent is an element of a crime. Question: is lack of motive a proof of innocence? The answer is, of course, no, because motive is not again an element of a crime. In contrast to that, can a crime be committed without an intent? Pwede bang i-commit yung crime kahit walang intent? Of course, yes. Kaka-discuss lang natin. Motive is relevant. Motive. Intent can ang intent, even if walang intent, pwede pa rin makommit yung crime because meron tayong tinatawag na culpable crime, yung walang intent but still they are criminally liable. Okay? So, when a motive, na let's say for example, there is no intent, ang ano lang na meron tayo, motive. So, when is motive relevant? So, motive is relevant in three cases. One, when there is doubt to the identity of the accused. So, walang nakakaalam, walang nakakita, walang witness sa pagpatay. So, anong titingnan ng mga pulis dyan? Hindi ang intent kasi hindi nila alam sino yung pumatay. It's the motive. If you could recall yung si Rahman, yung transgender sa Butuan na pinatay niya yung best friend niya dahil sa selos. At first, wala nakakita sa crime. Wala nakakita sa pagpatay. But itong si Rahman kasi, lagi siya nagpo-post online, nagpo-post siya online doon na saan ka na, parang nagtaka yung mga tao, bakit parang advanced masyado siya sa information na wala pa lang, pero sinabi na niya namatay na minention pa niya yung paano niya pinatay yung babae na 15 years old. So there, it was not the intent that was compelled the police or the enforcers or the policemen to identify the suspect, but it was the motive. Okay, so take note of that. The second one here is when there is no eyewitnesses to a crime, as what I have been mentioned. The third one is when the crime is relevant to libel and malicious mischief. So in libel and malicious mischief na mga felonies, dito relevant yung motive, no? Kailangan mong kasi titingnan kasi yan, ano bang motibo mo sa pag-post nito? Do you have any motive? Kasi if your motive is to malign the person or ipahiya yung tao, then libel constitutes. Or the libel is being constituted in that particular manner. Okay. In evidence, let's proceed to evidence. Dapat ano tayo dito, integrative tayo or integrated yung discussion natin. In evidence, halimbawa, nagkwento ni Pedro kay Juan, walang iinuman sila, napapatayin niya si Jose kasi galit siya dito. And after 2 days, namatay nga si Jose. So si Juan ngayon yung witness. Magte-testify siya ngayon si Juan kasi walang eyewitness doon sa crime. Kasi natagpuan lang napatay si Jose. Ang testimony ni Juan is, sinabi ng lalaki niyan sa akin na gusto niyang patayin si Jose. So the testimony of Juan was objected by the defense lawyer. So what would be the objection of the defense lawyer? ito yung concept ng res inter alios acta. So, anong ibig sabihin ng res inter alios acta? It is the law. It is a law doctrine which holds that an act or omission cannot be prejudiced a third person. So, ito yung tinatawag na mind your own business. What will be the possible counter of the prosecution? He may say, Your Honor, no, the statement of the accused to the witness is an admission against him. Ito na ngayon ang magiging subject ng controversy. Sinabi nga ba talaga ng accused yung claim ng witness na papatay niya? So this is now the motive. So motive is relevant to the crime when crimes involve libel and malicious mischief. When you have no eyewitness, but you want to establish a motive. So what is the reason of why criminal intent is material? The reason is this. It is a material to determine criminal intent because of a mistake of fact. That is why it is important to determine criminal intent to avoid mistake of fact. So mistake of fact is an absolutory cause. Take note of that. One of the circumstances affecting criminal liability. Pag sinabi nating absolutory cause, it means walang criminal liability. No? Take note of that. I do not know if ito yung sinasabi ko nga sa mga students ko sa criminology review na you should also read cases, especially nung criminal law, because through cases you will be able to understand how the Supreme Court applied the cases. Let's say, for example, I will just mention the case of Atchong. No, this is an example of a mistake of fact. Nung mga panahon na yon, is uso yung akyat bahay sa lugar nila. So itong si Atchong, meron siyang roommate na gumala, so hindi pa umuwi. So nag-lock siya ng pinto, tapos may kumatok. So nagtanong siya, sino yan? So yun yung nangyari. Hindi sumagot. So sabi niya, pag hindi ka sasagot, gagamitan kita ng kutsilyo. So yun. Hindi pa rin sumagot, katok ng katok. So pagbukas niya, ay, pinatay niya. So here, ang Supreme Court, sabi ng Supreme Court, walang kasalanan si Atchong. This is a mistake of fact. Mistake of fact because had he known na roommate pala niya yung kumakatok, ay hindi niya papatayin. Okay? So, kasi hindi niya alam na roommate niya yon, and then parang natakot na, nagkahalo-halo na din yung mga circumstances. So, the Supreme Court decided that this is a landmark case of a mistake of fact. Walang criminal liability dito. So another example, the husband discovered his wife and her paramour. So yung babae may kabit. So hinabol ng husband yung paramour, yung kabit na lalaki. So while hinahabol na yung paramour, yung pinsan ng kabit na lalaki ng babae ay nandoon din sa same place. So of course, pinsan niya, nakita niya hinahabol yung pinsan niya. So the first thing na talagang gagawin ng isang pinsan is to really defend yung pinsan niya. So in defending the paramour, napatay nung pinsan ng kabit yung husband na humabol sa kabit. Nakuha niyo yung story? So yung husband na ginagukod yung yung kabit ng asawa niya na babae ay napatay nung cousin kasi nga defend niya. So ang question nito is, what crime did the paramour commit? So it's very clear, adultery yung paramour. Another question is, in the case of the cousin, is he liable? Yung cousin niya na pinagtanggol yung kabit. The answer is no, because there was a mistake of fact. Have the facts been correct as he believed it to be, he would be acting a valid defense to a family. He had no criminal intent. So, nag-exercise lang din yung pinsan of a valid defense to a family. No? That's under Article 11. Okay. So in mistake of fact, there is no criminal intent. Take note of that. So the exemptions to mistake of facts when there is negligence or bad faith on the part of the accused. Kailan man nagkakaroon ng bad faith on the part of the person defending? Let's say, for example, yung pinsan, nakita niya, hinahabol yung pinsan, yung kabit, yung husband niya, ay may galit pala din siya doon. So, dahil sa galit niya, aside sa gusto niya ipagtanggol, yung pinsan niya na hinahabol, who happened to be the paramour of the wife of that husband, ay sinuntok niya kasi meron talaga siyang galit. So here, iba na yung story. There is criminal intent na. So therefore, he is no longer covered under the principle of mistake of facts. Kung hindi, ay subject na talaga siya sa murder or homicide as the case may be. Okay. So let's proceed now to Article 4. I think since medyo gabi na, we will just break this discussion into series man ito. No, I named this one a series, so I think 1 hour would be enough. And then we will schedule again for another series or session to continue our discussion. I hope meron din kayong na-recall or natututunan dito sa ating live discussion. So now, in Article 4, we need to relate Article 4 of the Revised Penal Code to the following. 1, different forms of self-defense under Article 11. 2, Articles 48 and 49, Paragraph 1 of the Revised Penal Code. 3, Articles 286 and 339. 4, crimes against persons. And 5th, death under exceptional circumstances. So isa-isahin natin yan. Now, this has 2 parts. So this part is the instances where criminal intent is different that of a resulting crime, such as the praeter intentionem, aberitio ictus, an error in persone. So the second part focuses on impossible crime. So this article features the question, is the accused liable? So ito yung ano. So take note, in this article, the accused is committing an unintentional felony, not culpable felony. Okay? Take note of the difference sa intentional and culpable felony. Pag sinabi intentional, there is intent. Okay? Meaning to say his actions are felonious. In other words, you need to know if the action is felonious or not. So pag kayo nahuli of resistance of arrest or disobedience to authority, this can never be subject to compromise or compromise. Halimbawa, hindi ka wala kang quarantine pass. Pumunta ka, hinanapan ka ng pulis ngayon or violate mo yung curfew. So, ano mangyayari dyan? So, kung nag-violate ka, tapos sinagot-sagot mo yung pulis, binastos mo yung pulis, worse, sinampal pa, okay, take note that the arresting officer cannot execute an affidavit of desistance. So, hindi niya pwedeng iurong yung yung ginawa mo, kahit naawa pa siya sa'yo. This would result the dereliction of duties. Halimbawa, naawa yung pulis sa'yo, hindi ka kawawa ka naman, hindi na lang kita kakasuhan. Ay mayroong balik yan sa pulis. It's an example of dereliction of duties as a public officer or tinatawag nating prevarication or prevarication. So, ang ibig sabihin yan, walang choice yung pulis kundi filean ka talaga ng case. Kasi pag hindi kanya pa-filean ng case, babalik din sa kanya yung kaso, yung tinatawag natin prevarication or dereliction of duties as a public officer. Now, let's proceed to aberitio ictus. Alam naman natin yung aberitio ictus, no? Mistake in blow. So, this is an instance which a person commits a felony although the wrongful act done is different to what is intended. Halimbawa, gustong patayin ni Bea Alonzo si Julia kasi na talagang pinag-awayan nila yung si Gerald Anderson. Pag baril ni Bea kay Julia kasi nga nanginig-ginig yung kamay ni Bea, ang natamaan si Pokwang. So ngayon, this is an example of aberitio ictus kasi ang gusto naman talagang patay ni Bea is si Julia, pero yung natamaan niya, yung katabi niya ni si Pokwang. Here, the accused must have an intent to commit the crime. So why is this very important? No, nirelate natin ito sa self-defense and death under exceptional circumstances. So they are important because they alter or change the degree of criminal responsibility of the accused. So instead na yung crime na nakumit or yung felony na nakumit is murder, so bababa yung felony or yung natin imposable penalty or yung case magiging na lang homicide, which is punishable by, let's say namatay talaga si Pokwang, so that's a homicide, no? Consummated homicide, punishable by reclusion temporal instead of murder, which is technically punishable by reclusion perpetua, the highest penalty. So here, the single act constituted two or more grave or less grave felonies, one against intended victim and one against the actual victim. So in other words, ang aberratio ictus pala guys is an example of a compound crimes under Article 48 of the Revised Penal Code. So as a result, the penalty to be imposed is maximum period of the most serious penalty of the resulting crime. Halimbawa, ang nag-commit is attempted homicide against the intended victim and homicide against the actual victim. In relation to the doctrine of pro reo, alam naman natin yung doctrine of pro reo, kung ano yung mababa, ano yung favorable sa accused, yun yung i-impose natin. Even there are two felonies committed, only one is to be imposed and the accused under aberratio ictus. So take note again, guys, that aberratio ictus gives rise to a complex crime. The single criminal impulse demonstrates lesser perversity or propensity than when the crime are committed with a different and several actions. So reclusion perpetua is a single indivisible penalty. Take note, this has no period. So walang period yung reclusion perpetua. Okay. Bakit? Yung batas nagpo-provide siya ng period. Okay. For the purposes of availing the probation and good conduct allowance or yung tinatawag ng GCA. No? So, different forms of self-defense under Article 11 na tayo. No? Yung one is aberratio ictus cannot be used under self-defense. O take note this, ha? Yung aberratio ictus cannot be used under self-defense. In the course of self-defense, if a man defending himself, pagbaril niya sa kalaban pero iba ang natamaan niya, ito ay isang bystander, is he liable? The answer is no, because he is not committing a felony when he is defending himself, unless there is negligence on the part of the accused. Now, under naman sa death under exceptional circumstance, under instance where aberratio ictus be applied as death under exceptional circumstances, yung question natin dito is, binaril mo ang paramour, okay, let's continue the example kanina, while they are having sexual intercourse with your wife, pero yung room boy ang natamaan mo. Are you liable under aberratio ictus? No. You have no criminal liability under these circumstances because here the accused is not committing any felony unless there is negligence on the part of the accused. So ano naman yung tinatawag nating different bullet principles in aberratio ictus? So di ba technically yung aberratio ictus isang mistake in blow, isang blow lang. So isang bala, due to isang bala, nag-commit siya ng dalawa or higit na felony. So in different bullet principles, it is relevant because under this principle, there are two crimes committed in a single act. The bullet that killed the intended victim is different from the bullet killed, no? The third person. So here, dalawang putok yung ginawa niya. So yung tinatawag natin siyang different bullet. So the Supreme Court held that there must be two different charges even under aberratio ictus. Okay. So if the single act produces two or more acts punishable by the revised penal code and special law, two separate charges must be filed. So take note of that, ha? Again, if a single act produces two or more acts punishable by the revised penal code and special law, two separate charges must be filed. But in an aberratio ictus, only one. Let's proceed to error in personae. So question, why does it affect the criminal liability of the accused? Here, the accused has an intended victim. However, he killed another person. The difference here is that in error in personae, the intended victim is not in the crime scene. Kasi pag nasa crime scene siya, tapos iba ang napatay niya, this would result to aberratio ictus. Okay? So how does this affect the criminal liability sa error in personae? It would mitigate the penalty. So bababa yung penalty. So as compared to aberratio ictus, this has a lesser penalty. The penalty imposable in error in personae is penalty prescribed for the offense which has lesser penalty in its maximum period. So this is for the application of the transfer intent rule where the actual victim is different from the intended victim. So example, if the intended crime is homicide but the resulting crime is parricide, let's say for example, meron kang kakompetensya sa pangliligaw, gamitin natin siya sa pangalang Rose Sabihon. So itong si Brandon is nagselos siya kay malinis kay Edward kasi niligawan ni Edward yung crush niya na si Sabihon. So plano ni Brandon na patayin si Edward malinis. So inabangan niya, dilim-dilim yon. Pagpatay niya, kasi kamukha pala ni Edward yung father ni Brandon. So, pag-atake niya, akala niya si Edward yun, but only to find out it was pala the father of Brandon. So, instead that, no, na homicide or murder yung case niya, parricide, pareho lang din yung punishment. Let's say homicide na lang yung case niya na plano niya kay Edward. So, since napatay niya, father niya, sa parricide ang kaso. So, yun yung effect ng error in personam. So, mistaken identity is different from mistake of fact. Mistake of fact is an absolutory cause, while mistake in law is not. Okay. Preter intentionem. Okay. Ang preter intentionem is, iba yung intention mo sa nangyari. How does it affect criminal liability of an offender? This is a mitigating circumstances or circumstance. This is a favorite question din ng examiner. So, meron tayong term dito na proximate cause, that cause which in natural and continuous sequence, unbroken by an efficient intervening cause, produces the injury and without which the result would not have occurred. And more comprehensively, the proximate legal cause is that acting first and producing the injury. So, yung proximate cause, let's say for example, para mas maunawaan natin yung proximate cause. Hinabol ni Ana si Maria, so sa paghahabulan nila, si Ana ay nasagasaan. So, may kasalanan niyan si Ana. Kasi kung hindi niya hinabol si Maria, hindi yung mamamatay at masasagasaan. So, yung proximate cause dito is si Maria, yung paghabol ni Maria. That's an example of a proximate cause. Ano naman ang panglaban natin sa proximate cause? Ang proximate cause, pwede siyang malabanan ng efficient intervening cause. Let's say for example, hinabol-habol ni Maria si Ana si Maria, tapos huminto na si Maria, tumakbo pa rin si Ana, ay natamaan siya ng kidlat. Okay. So ito, pagkatama ng kidlat, this is an example of an efficient intervening cause because it's different. Hindi naman kasalanan ni Ana na tumama yung kidlat sa kay Maria. So that is an example of an efficient intervening cause. Okay. So last topic natin is the impossible crime. So what is an impossible crime? So an impossible crime is an act which would be an offense against a person. Parang mayroong andito si Malinis nagti-thank you. Okay. You're welcome. So, okay, let's continue sa ating na topic. It's impossible crime. An impossible crime is an act which would be an offense against a person or property were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. So you only invoke impossible crime on the following: one, crime against property and person. This is exclusive. And second, when the act did not result in any act penalized by the revised penal code, because the impossible crime is a crime of last resort. Okay, take note of that. So it is a crime of last resort since the act performed should not constitute a violation of another provision of the revised penal code. Ang pinakasikat na example na impossible crime is yung homeboy, yung katulong na lalaki, palagi pa niyang sinisilipan yung amo niya na babae. So, pagsilip niya doon, nakahiga yung amo niyang babae, walang damit. So, na-arouse si homeboy, pumunta siya doon sa kwarto at ni-rape niya yung amo niyang babae. But only to find out, pag-rape niya, 5 minutes na palang patay yung amo niyang babae. So here, there is an impossible crime. Kasi ang rape can only be done kung buhay pa yung babae, namatay na siya. So there is an impossible crime. Pero if mayroong another felony na pwedeng makumit, aside from that, ay hindi siya pwede mag-result into impossible crime. So that is very basic. Okay? So, next, is impossible crime a crime? The answer again is no. An impossible crime is not really a crime. So it is so-called a crime because the act gives rise to a criminal liability, but actually no felony is committed. So the accused is to be punished for his criminal tendency or propensity, although no crime was committed. Okay? So I hope you have learned something no out from this kahit 1 hour lang. So kasi I understand also na limited lang din yung yung data or internet source ng iba. So we will just continue the lecture series. So we will continue where we ended para mas natin yung discussion natin. And nakaganda nito is you could actually rewatch because I will be uploading the live video then para mas may reference din kayo in the near future. So I will just share my tip also sa kung ano yung ginagawa ko is I transcribe the discussion. So I make notes also based on the discussion para mas malinaw, mababalikan ko talaga yung pagkatahi ng discussions on these topics. Okay, thank you very much and thank you for watching Wiser Pinoy TV. So do not forget to subscribe and of course click the notification bell so that you will be updated next time na mayroon tayong live session pertaining to criminology lecture series. So thank you very much. God bless and good night.